Good morning, everyone. It's 9 o'clock, so I'm going to start the meeting here shortly. As a reminder, the AG has informed us that we need to have our videos on while present in the meeting. So I'll start joining me by video. We usually do a video, and I can't tell because it's Microsoft Teams. Go. Now I see videos. Good morning, everybody.
Good morning.
Okay, somebody responded. I need to see if my microphone worked. All right. Let's give it, let me make sure they've let everybody in that needs to be in so far. Senator Perry just texted he's having some technology problems. Don't wait for me is what he said. Okay. All right, I am going to go ahead and call this meeting to order. This is the duly noticed December 10th, 2021 notice of public meeting for the Child Support Guidelines Committee. And I am going to go ahead and call roll call. Ms. Baker?
Present.
Ms. Kaplan? On behalf of Ms. Chapel.
Correct. Present.
Ms. Cliff?
Hello, this is Adam Hughes, a Deputy DA in the Clark County DA's office, and I'm present as Karen Cliff's designee today.
Okay, thank you very much. Assemblywoman Cohen?
Here.
Ellen Crasilius?
Here.
Jack Freeman? Assemblywoman Hardy? Senator Harris? Judge Hoskin?
I'm here.
Senator Pickard? Told us he would be running late. Judge Robb?
Present.
Mr. Sanford?
Present.
Judge Shirley? Told us he wouldn't be able to be here today. Justice Stiglitz? Said she would be running late. And myself. We have 9 present of the committee, thus we have a quorum. And we will move on now to public comment. If we have staff available to assist us with public comment right now.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. So Kimberly Woods, you've been unmuted if you want to go ahead, and then we can accept Mr. Willicks.
Okay, Ms. Woods, you have 2 minutes.
Okay, my name is Kimberly Woods. I'm a CPA with Reuben Brown. I have a couple of items requesting clarification of the language of 425.025, calculating gross income. Specifically in subsection B, where it says not including principal. I'm wondering if that was specifically intended to exclude losses from the calculation of gross income. And then in subsection K, where it says undistributed income of a controlled business, I don't see any language that directly addresses distributed income, which could be interpreted that income could be double counted. And then the reasonable allowance for economic depreciation under subsection K, whether that's intended to tax assets because there's a reference to the tax code, or whether that could be more broadly interpreted. So those are my questions for clarification in the language. Thank you.
Okay, thank you, Ms. Woods. We appreciate that. Being that that is not an item on the agenda right now, we can't approach it, but if you wouldn't mind emailing me at kim@surrattlaw, surrattlaw.com, and give me those specific items that you just stated, and I will make sure they are placed on the next agenda so that we can specifically address them.
Thank you.
Okay, thank you. All right, Mr. Willick had his hand raised also.
Mr. Willick, you've been unmuted, so if you'd like to go ahead with your public comment.
And Mr. Willick, I do have you on the agenda also, so you have 2 minutes in this item on the agenda.
I'll reserve at this point if I've got a separate section on the agenda I don't want to repeat.
You do. Okay, thank you. All right, Ms. Thomason, do we have anybody else wanting to give public comment?
I'm showing no other hands are raised at this time.
Okay, thank you very much. We're going to move on to agenda item number 3, which is approval of meeting minutes. Do we have any discussion regarding the November 19th, 2021 meeting minutes?
Madam Chair,
Yes, ma'am.
this is Bridget Robb for the record. My name is misspelled in the minutes, and this is just a procedural question. These sets of minutes are somewhat unique in my experience, and I've done this kind of thing for a long time. It's my understanding that these proceedings are being recorded, so I'm a little unclear why the minutes are reading like a transcript. Is that the way we're going to have this going forward?
Yeah, the DWSS has determined that they are going to utilize Microsoft Teams so that they can transcribe it word for word. Part of that came from the discussion of placing these on the DWSS website so that there's actually, quote unquote, not legislative, because we're not a legislative body, but committee intent demonstrated, or a way to look it up. That's the way administratively DWSS has decided to proceed with it.
That was just my question. I have no quarrel with it.
Okay, but we do need to correct the spelling of your name.
Yes, please.
Yes. Okay. Any further discussion?
And
Madam Chair,
just for clarification, that spelling is ROBB, not simply ROB.
Madam Chair, I just wanted to raise that I didn't receive these minutes until yesterday afternoon, so I haven't had a chance to go all the way through them. I guess what you said a minute ago probably alleviates the concern. If they're a transcript, and I probably don't have any problem with them, but it would be nice if I could get these ahead of time. I like to be prepared for these and getting them as late as we get them. And I know people are busy, but it makes it very difficult to have an effective meeting if I'm unprepared. And I assume most everyone else is unprepared unless they spent last night going through this. So that's just my comment.
Yes, and I know DWSS is very well aware of my concern regarding that issue also. It is also the reason they've decided not to go back to Zoom because this platform, although it's a little bit clunkier for meeting purposes, is easier for them to produce those minutes a little more timely. So the hope is as we move forward, Microsoft Teams is going to make that possible for them. I hope. But I agree. We're also having shorter time periods between our meetings right now with the intent to keep the agenda moving forward so that we can submit something in time that LCB can process it before the next session. So hopefully we can stay on top of it. But the staff at DWSS is in charge of that and they're well aware of it.
And Madam Chair, this is Bridget Robb for the record. It's not just the minutes. There were some pretty meaty comments that were made by Marshall Willick and his entities. And I don't have any ability, given that we got them late yesterday afternoon. I studied last night. I got up early this morning, but I am still unprepared to go forward with a lot of that language.
Yes, and I agree, but just for clarification on the agenda today, Mr. Willick is present. He is being given a normal, that's not the right word, a longer time slot on the agenda to present those materials to us with the expectation of getting his explanation of it, and then we'll have a further discussion about it at the next meeting. So yes, I agree. We have not had time to digest what has been given to us by the AML, but we do have them. I did add them specifically to the agenda for that purpose. And
Thank you, Madam Chair.
And I do intend to take them out of order and have Mr. Willick present first, even though it's agenda item number 13, to assist us that we may skip a few other items in the agenda for now after his presentation so that we can absorb the information. Anything else on the minutes? Yes, Assemblywoman Cohen.
Thank you for recognizing me, Madam Chair. Getting back to with the transcript, I would just, in order to head off any problems in the future, the vote count to me seems like it could be a problem because the transcription, I noticed when I reviewed the minutes, said just that something passed. And I'm sure it was unanimous, but it didn't specifically say that, and it didn't. So I guess that's maybe something that when after each vote, if you could just repeat, if you could specifically say passed unanimously or passed with these people abstaining or passed this way or that way, I think that might head off some future problems.
I agree. So what I would like to do is have DWSS has the actual recording. They should be able to go back and give us what the specific vote on each item. And if everybody is willing to entertain not doing a motion on these minutes for right now, we can allow them to make the corrections and then we'll vote on it for the next meeting. Okay, thank you. Ms. Tomlinson, Senator Pickard is saying that he's waiting for somebody to let him in. I don't see him in the attendees, but maybe he is the phone number that is there.
If he is the phone number, I can't move him to a presenter because it's just a phone number. There's no like video attached to it.
Okay.
I'll send a request to him to join the meeting and see if that works.
Okay, thank you. I appreciate that. All right. Any further discussion on the meeting minutes? We'll get this right at some point with documenting what this committee is doing so that we get sufficient information to the public. All right. As stated before, I'm going to take the agenda out of order and we are going to skip to agenda item number 13, discussion and recommendations on the American Academy of Matrimonial Lawyers proposal for changes to NAC 425. And we have Mr. Willick present. I believe we will have to switch him back in order for him to give that presentation. I don't know, Ms. Tomlinson, is it possible to have him on video or will we just have audio with him?
I'll move him to a presenter so that he can do video as well.
Okay, thank you. And I believe Senator Pickard just told me he is present. Are you here?
I am here.
Okay,
good morning.
Good morning.
And Mr. Wilk has been moved to a presenter, so he should be able to turn on his video.
Okay, thank you. Mr. Willick, are you present?
I am, but I do not see a video control. Oh, it's marked disabled.
Okay, well, we can hear you. If you're okay with us just listening, we're good too. If from the materials that you provided us, if you need me to put any of them on the screen, I can attempt to do so.
Thank you. Madam Chair, members of the Commission, thank you for this opportunity and for your time. My name is Marshall Willick. I'm the observer and liaison from the Nevada chapter of the American Academy of Matrimonial Lawyers. This commission directed that rather than simply identify problems with the existing regulations, it sought specific wording changes to address identified concerns. The Academy Working Group, starting with a detailed analysis from Sean Metter, sought to do so. In the time allotted, it's not possible to detail each proposed change, but they have been submitted in writing in the form of proposed changes, a red line, and an explanatory memo, and fall into three main areas. Those are a structural reordering, terminology, and amendment of specific problematic wording. First, we suggest a structural reordering of the steps to correct the repeated problems of judges in some courts not agreeing on what to do in which order, which has led in practice to very different results in similar situations. Essentially, just making sure the courts do their analysis in the same procedural order should largely rectify that problem. In shorthand, the chapter recommends that a court first determine whether it is going to determine guideline schedule support by looking for an agreement, and if there is one, determining its validity, and then testing for poverty level support. Either of those would be a derailing of determining guideline schedules. If guideline schedule support is to be determined, then the math is done per the regulations. Next, the adjustment factors are looked at, if any are applicable. Then medical and child care are individually determined and allocated after guideline schedule support has been determined. The terminology changes mainly just provide uniformity from one specific regulation to another to clarify the meaning of the terms used. Some terms that are not defined have caused problems in the real world of family court cases, like the term basic needs, which has been interpreted by some to modify the meaning of what the regulations as a whole set out in detail as to establishing a guideline schedule amount, then adjusting it, then considering medical and child care. We recommend elimination of some undefined terms, using normative language to specify that the regulations set out specific procedures for steps to be taken by courts in allocating child support. These specific wording changes are intended to address the specific problems that have been reported from practitioners. Specifically, clarification that imputed income addresses the earning capacity of the individual obligor and not the income of a new spouse or cohabitant, and specifying how imputed income fits within the regulatory scheme as part of establishing guideline schedule amount, not something outside of it. Addressing the language in 425-150 sub F, which has had wildly different interpretations. Some people believe that the reference in that regulation to other party means the parent other than the obligor. Others have argued that the term means the obligor's spouse. And still others argue that the term refers to the obligor himself for purposes of making an adjustment, that is, permitting the doubling of any guideline schedule amount by counting the income twice. Our suggested rephrasing specifies that the amount of an adjustment on that factor is not to be more than the obligation of the other parent. We presumed that it was intended for Wright versus Osborne offset situations. But if the commission meant something else by using those words, the language should be clarified to specify the actual intention. At least as part of the non-legislative history of this commission, there should be a record that relative household income was never intended to be simply a carte blanche to ignore the guideline schedule amount when one parent has a significantly greater income than the other. What was intended to be addressed by the relative household income should at least be discussed and some record made of it, because it has proven problematic in the real world. Finally, we've submitted a couple of papers submitted at the recent Advanced Family Law Seminar. One dealing with the relationship between child support and alimony, each way the math might be done, and showing the mathematical effects of the various choices to be made. The other paper addressing the relationship between child support and parenting time in multiple scenarios, which includes a recap of the various steps in development of our current child support law, legislatively and in the case law, for anyone who is interested in either topic. The chapter stands ready to provide any further information or assistance that this commission might solicit, and to answer any questions that this body or any members of it might have. We have addressed the alimony and multiple family issues by explaining in the memo the mathematical effect of the current regulations in both primary and joint custody situations, and suggesting implementation of an explicit first mortgage approach addressing prior but not subsequent child support obligations as recommended by the 1985 Governor's Commission and the 1992 and 1996 Child Support Statute Review Committees. Thank you. That is as much detail as I can get into at this time, but I'm happy to answer any questions that anyone might have.
Mr. Willick, for those that are on the committee that are unfamiliar, can you please explain what the AAML is?
Certainly. The American Academy of Matrimonial Lawyers is an organization, a voluntary organization based in Chicago of generally leading practitioners in family law. And the structure of the organization is that in Nevada, for example, you have to already be a certified specialist just to apply for Academy membership. There are requirements for recommendations from judicial officers, experience and professional credentialing, and a examination on matters of national law. The purpose of the Academy is to improve the practice of family law. It has a slightly longer mission statement, but basically it's an organization of leading family law practitioners.
And can you advise the committee as to the input of the Nevada chapter on these changes that you presented?
I'm not sure I understood that question, but
was it voted on by the chapter?
Oh, yes, I'm sorry. Yes, there was a working group. As I said, we started with the work of Sean Metter, who wrote a lengthy memo, which I believe came up at a meeting about 2 months ago. Then a working group tried to turn those recommendations into specific wording changes at the invitation of this commission. Then the entire work product was circulated to the Academy chapter and voted on. There were no votes against, one abstention, and some people didn't respond at all, which I'm afraid is sort of the way votes go in the real world. But basically, this is an Academy submission, and it appears to be consensus of the recommended changes.
Okay, thank you. Does the committee have any additional questions for Mr. Willick? Hearing none. Mr. Willick, as stated at the beginning of the meeting, no one's had very much time to digest what you have provided, and we want to give it sufficient consideration. So we will be putting the items that are relevant to this on the next agenda, along with your materials subsequently for us to discuss and review.
Thank you for the time.
Thank you. We appreciate the effort. It's nice when the organizations come forward with actual suggested changes and not just complaints. We greatly appreciate the efforts. Judge Rob, you have something?
Yes, I was just wondering, Mr. Willick, since we are going to be able to dig into this more fully next meeting, would you be able to be available at that meeting for any questions at that time?
I or any other member of the Academy will make ourselves available at your discretion.
Mr. Willick, thank you so much.
Any additional comments?
Yes, Madam Chair.
Yes.
And Mr. Willick, since most of us...
Senator Pickard, sorry, I didn't state your name. I just want to make sure we're having issues with the transcription of the minutes. So we want to make sure we're real clear who's talking, what the votes are. So.
Not a problem. Chief Pickard for the record. I should be used to that by now. Mr. Willick, since most of us, excuse me, haven't really had a chance to absorb this, I think that your comments that were made will certainly be helpful in understanding them as we go through them. I wonder if you have written those out, and if so, would you make those available to us as well?
I have. I believe they've been copied. All the materials have been copied to Chair Surratt, and I think to both you and Judge Hoskin. I wasn't directed to send anything to anybody else, so I did not.
Sure. No, I'm just talking about the comments you just made to us. I didn't see those. They may have been in there, but what you just presented to us, I think if you have that in written form so we could refer back to it, would be particularly helpful.
I have, and I can. If that's your direction, I'll copy it the same as the prior materials, unless directed otherwise.
That would be great. Thank you.
Yeah, we will transcribe these minutes, but if you could provide that sooner, Mr. Willick, it will give the committee, as we discussed at the beginning of the meeting, we're having some timing issues of the minutes coming out. That way the committee has it in front of them sooner. Okay, additional comments from the committee? Okay, hearing none. With that, as I stated, we are going to skip several items on the agenda unless a committee member tells me they'd like to still discuss it outside of ability to review in detail the materials from the AAML. That brings me to believe that the next item that should be discussed is item number 7 on the agenda. Is there anything in items number 4, 5, and 6? I'll give you guys a moment to review those to determine if you want me to address those agenda items first.
Madam Chair, this is Judge Hoskin. Did we receive the master document? Was that one of the?
It was going to be, it's part of these edits from AAML. I was going to incorporate them in, and yeah, timing wise, that did not happen.
So we don't have them. I just
We
want to
do
make
not.
sure it's not something that I'm missing. All right.
No.
All right.
Okay. With that, I believe we will start with agenda item number 7, discussion and recommendations on whether income from bonuses should be included in gross income and how the receipt of a bonus impacts child support, and in particular, the language in NAC 425.025. We discussed this on the last, during the last meeting with input from Senator Pickard, and the direction was to work on language. Senator Pickard, do you have follow-up on that?
Yes, and those were included, those comments or that suggested language was included in what Ms. Tomlinson sent out. It's the changes to 425.025. We proposed, or I have proposed a new subsection B, which takes essentially the same or similar language from subsection A regarding its consistent and accurate determination. So it just reads money earned from bonuses, gratuities, or other additional monetary compensation if such compensation is substantial, consistent, and can be accurately determined. And just as a reminder for those who may not have been here last meeting, this was a result of a temporary order that was granted by a district court here in the 8th. Where because the term bonuses did not appear in subsection A, she determined that it would be more appropriately used as part of a discussion about alimony and not as inclusion in income for purposes of determining child support. It's the first time I've ever heard a district court say that bonuses should not be included in calculation of gross income. But, you know, I also operated under the assumption that it was included in the language. So when I went back and looked and it wasn't there, she was accurate. We didn't say bonuses are to be included. And so I thought, okay, that's an easy fix. So that's why we put it in there. We want to make sure that it's clear that if someone is receiving bonuses, it really should be used as part of the child support calculation, and take away the argument that because we didn't include it in the language that it's not included in income.
Okay. Any committee comments on this proposed language? Yes, Assemblywoman Cohen.
Thank you for recognizing me, Chair Leslie Cohen. So I appreciate that between subsection 1A and 1B that the language is consistent, but I just want to unpack the word consistent in subsection B, because I don't want to have a situation where someone gets a big bonus, like tens of thousands of dollars of a bonus, and they can say, well, I'm not going to get that regularly, and have it be considered not consistent, and then not addressed as part of the child support calculations. So I don't know if I'm overthinking it, but I just want to make sure we consider that.
Keith Picker for the record. I'll address that. Yours is a good comment. It's one that I've heard in the past in many cases. I think that the word consistent is important, or something like it. I'm not married to any particular language, but it has to be recurring, and maybe that's a better word. Because if it's recurring, if it's happening over time, it's something that the court can rely on. Even one time a year can be considered consistent. But if it's a one time only, and we see those from time to time, where someone gets a bonus simply because the company did well, or they did particularly well themselves, but it's not part of the compensation package, and there's no indication that it will continue to be paid, I think it's important to make the distinction so that we don't make a permanent or semi-permanent child support award on a one-time event. I mean, we see that all the time, but if I'd love to hear from the judges from a decision-making side, how you would view this language versus recurring or some other.
Judge Hoskin for the record. In my mind, and certainly Senator Pickard, I'm not discounting your experience. In my mind, this is wholly unnecessary language. And bonuses are part of salary and wages. I don't know how you could argue to the contrary, and I'm sure I have colleagues that are making that more difficult. I appreciate Ms. Cohen's approach to it, and I don't know that I can draft around that other than the ability to have the discretion to determine whether that should be included as income. And it's not just bonuses that could be part of what in my mind is salary and wages for calculating child support. But my experience may be different because I've been part of this committee for so many years that I have kind of a right-sized award approach to my child support determination. So I don't know that I'm opposed to the language. If I was going to make a suggestion, I would include it as bonuses as part of one of those things we're doing in A. But then we get back to that creating a list, which eliminates the ability to include things beyond what's in the list. So my only fear in all of this is unintended consequences, and I don't want bad facts to result in bad law is my only concern on this. But I do understand that not everybody looks at it the way that I look at it. So maybe Judge Robb has a different approach.
Judge Robb? You're reaching, so I'm assuming you're going to speak.
Yes, Bridget Robb for the record. I agree with Judge Hoskin. I hate to have one person kind of drive what we're doing as far as our recommendations. If we are going to go forward with this kind of language, quite frankly, I like recurring potentially better. But I also have some problems with substantial, because I can see some of my colleagues thinking substantial has to be something in the tens of thousands when it may be less that would make a difference to child support. And so I would kind of like, if we're going to use this language, I would rather define that portion in the negative by saying not nominal as opposed to substantial. It makes it clear that, you know, a $100 bonus that you get one time is not something that's going to impact child support, but something $1,000 a month is going to add up at the end of the year, and that is not nominal. So if we're going to use that language, that would be my suggestion with regard to that portion.
This is Kim Surratt. I will state for the record also, I had commented during the last meeting that I would look at, try to take a look at some of the other statutes in the country. What I did was went to the materials that we received early on in this committee from several other states. I just was not successful in finding anything. So many of them go back to the language we have in subsection A, or very similar language to what we have in A. And I guess the only conclusion I can make from that is because Yeah, it's supposed to be part of salary and wages, right? But I don't know. That's the only conclusion I can make. I did not look at every state, of course. I went to the easiest I could, which was the materials we already had from the states that we had been relying on in creating our new statutes. So, any other comments from the committee?
Well, if I may, let me just respond a little bit. I agree that this should be, and in every prior case I've had, bonuses have been deemed to be part of salary, whether or not it's stated in a compensation agreement. This one was in a compensation agreement, so it should have been clear. But it was the approach that would take an appeal to the Supreme Court to reverse. And obviously, on a child support question, clients are likely, and in this case, were unwilling to spend the money to file a writ to clear this up from the perspective of the appellate court. My concern is if we're going to allow one or more judges, as we all know, when one judge does something, others are sure to follow. And you know, I think it's unnecessary for us, even though the language to those of us that have approached this, and it sounds like Judge Robb and Judge Hoskin have approached it the way I have, but you know, I think it might be a mistake for us to assume that it's unnecessary language because everyone thinks or everyone should take the same approach. And so clearly we have an example of one who does not. And I think we need to be clear in our direction to the judiciary, as reticent as we might be to make lists, to include what should be obvious. And so that was my thought, to make sure. And if we want to say, if we want to include this language, instead of having a separate subsection, but insert wages including without limitation, bonuses, comma, gratuities, comma, money earned from overtime pay and et cetera. I'm happy to do that. I just thought that since we were talking about a discrete issue, to drop it into a separate subsection, particularly since bonuses aren't quite the same as money earned from overtime, because overtime will be included in the normal pay stub as a regular thing. You know, we have judges who will say, well, you know, they only got overtime once or twice in a year. It's not regular. I'm not going to include that. But you know, bonuses often happen once a year. So I do think it's kind of a slightly different species of income. So I think it's probably appropriate to put it in a subsection. I do like the idea of not nominal, and recurring, I think, might be a better word. But I would urge the committee to adopt this simply because we want to avoid having to make the Supreme Court be legislative in their role and say, no, this is what should happen, where we have an opportunity to do that in our rightful order.
Additional committee comment? Okay. Does anybody have the desire to make a motion, or do you want to sit on this until the next agenda and think about it some more?
Madam Chair, Judge Hoskin, if I could make a suggestion, I'm less concerned. Well, I don't know that I'm overly concerned about any of it, but I'm less concerned about including the word bonuses along with salary and wages in A. And I just noticed that without limitation is referenced twice within about 6 words. So that's where I would fall on it. But certainly I understand the practitioner's concern and the litigant's concern with regard to that. But perhaps if we trail is not the word we use in this context anyway, and allow Senator Pickard to perhaps rework that language and then come back to it next meeting.
Happy to do it.
Yeah, and as far as my input on that, I think I also feel better about it being in A. I think last meeting I was thinking the section B would make more sense, but when you see things spelled out, your brain starts to realize, oh, maybe not. And you're right, we do have without limitation right above without limitation, and I don't know if we really need the first without limitation under above it, but we can discuss that later. I don't think that's critical. Any further discussion of the committee? Okay, I believe then at this moment, for the purposes of planning for the next meeting, Senator Pickard, you're going to work on this language again?
Yes.
And
Yeah, what I'll do, I will propose, this is Keith Pickard for the record, I will propose 2 options, and then we can kind of compare them side by side and decide which one we want to adopt.
All right. I like it. Okay, thank you. Moving on, we have agenda item number 8 and 9, I believe, needs some time for consideration of the AAML materials, unless anybody believes differently, and I will move on to agenda item number 10. Give everybody a moment to look and make sure, unless anybody wants to speak on 8 or 9 right now. Okay, hearing nothing, we're going to move on to agenda item number 10. Discussion and recommendations on the proposed language for NAC 425.115, subsection 3 for joint physical custody to change the language to 1/2 of the difference versus the full difference in child support values. And as of the last couple of agendas, we were giving additional time to DWSS to look into this, into the repercussions of this, and I believe, Ms. Kaplan, you have some comments on behalf of Ms. Chappell, who is not present today, or on behalf of DWSS.
So good morning, this is Kathy Kaplan for the record. And actually, Adam Hughes had sent out in the agenda from Ms. Tomlinson some calculations on what that would actually look like. We were proposing possibly putting together a committee, a subcommittee, to look at these calculations and see if it was the way that the committee wanted to move forward.
Okay, Mr. Hughes, would you like to speak on that?
Yes, thank you, Adam Hughes for the record. I did send out as an attachment for this meeting the joint custody samples. There are 9 examples of calculations done here. As you can see, though, under the proposal, all of the child support obligations would be reduced in every offset situation. There's concerns that the Nevada Kids program has already been built. It's been built based upon the existing calculation. This would be a change, and I believe there would be a fiscal impact to the state if this is adopted by the committee. Additionally, by lowering the child support obligation in every offset situation, this could result in additional families relying on public assistance in some of these cases.
Okay, do you have any information or input on what the fiscal impact to DWSS is? Because I know the software was created recently, so this would be one minor change, obviously, at the end of the process of the calculation, but what would that fiscal impact be, do you know?
Kathy Kaplan for the record. We don't have a dollar amount, but the impact would also be to the project. We are rolling the system out April, July, I believe, and October of 2022. So any changes that we make at this point in time would potentially delay that process, but it would be a change request because that calculator is built into the system.
Okay, for the purpose of this committee and others who aren't as familiar with the new program and what it is that you're doing, can you please explain that to everybody?
Sure, this is Kathy Kaplan for the record again. So the NV Kid system is actually a system replacement for the state of Nevada. It replaces our current database, which is called Nomads. It's a multi-million-dollar contract that we've been working on since 2018.
Okay, and at this time, MV Kids was programmed with the child support guidelines that this committee passed versus the old version, correct?
Correct.
Does the committee have additional questions on this issue? Or comments? Doesn't have to be questions.
Yes, Madam Chair.
Yes, Senator Pickard.
Keith Pickard for the record. I am not at all surprised that this would reduce the obligation of the payor spouse in a joint physical custody arrangement. By definition, we're changing the calculation to reduce it. So that's a given. And this wouldn't be probably the first time that I'm in a minority, but I may be in the minority, but I think this is a fairness question. It's not a fiscal question. What we're doing is we're transferring under the current guideline, we're transferring 100% of the difference of an obligation to parents who statutorily have an equivalent duty. So functionally, we're already, in my view, violating the purpose or the policy of NRS 125B or C 001, where the parties, both parents, have an equivalent duty, not a numerical equality, but an equivalent duty to provide economic support for their children. And where there's a difference between income, we should be dividing that income or dividing that difference so that each party bears the same burden. Now, when we're talking about the difference, I think that unless we're talking about a substantial disparity in income, we're not talking about a lot of money. We're talking about usually less than a few $100s. Often when we're talking about a significant disparity, now we can look at the adjustment factors where a court can make a reason to deviate from the equivalent duty. But this ultimately resolves, in my mind, around a fairness issue. And that's why I proposed this, which is to make each party responsible to the same degree to pay or to support their children financially. I think it's unfair to make one party pay more than their fair share of the obligation. If the consensus is that we want to maximize the dollars being transferred from one obligor to another, then the existing guidelines should stay where they are. But if we're talking about adhering to the policy of the state and making it so that the parties are bearing an equal burden, then I think it should be an equal distribution of that difference.
So this is Kim Surratt for the record. I'm actually significantly disheartened by DWSS using an excuse of the cost of change of the software when from day one, the purpose of this committee was for us to be flexible and ongoing changes to child support that did not have to wait for legislative sessions every 2 years and allowed for us to do what was right for the citizens of Nevada and the children of Nevada. That will require changes along the way. And if the position of DWSS is always going to be, but that's going to cost us money, for those of us that are not government workers and that are on this committee for a different purpose, which is to protect the citizens of Nevada and the needs of our children, it is very similar to what my position was and my vote was on when the new statutes were supposed to be applicable. As a private attorney and my role within this committee, I don't put much credence in it will increase caseloads or it will increase cost to DWSS. I would say that DWSS is going to have to figure that out. I can't imagine the software was designed in a way to be frozen in stone. with absolutely no changes, without huge financial impacts. But if it was, then it was the wrong move. And it was software that is not appropriate for what we're doing and what needs to be done ongoing. The needs of these children are going to be changing ongoing. Our low income chart's changing and going to change every single year. Our presumptions used to change every single year for our different income brackets. So changes occur and were occurring long before we ever changed these statutes, and need to continue to change if we're going to do what's right. Because we're going to learn there's mistakes. We're going to learn there are things that need to change. I 100% agree, Senator Pickard, that this is a fairness issue. I support it. I support it not just based on this committee. I support it on input I've received from other professionals, but also input we received from public comment during our initial proceedings, where we have individuals who are paying significant amounts of child support when they have their children 50% of the time, and it's not equal. The other party's getting more money as a result, and the amount of child support is unequal. That was a little bit of a soapbox, and I apologize to the committee, but any other comments from anybody else? I heard yes, I don't know who.
So this is Kathy Kaplan for the record. So it was not DWSS's intent to not move forward because of the cost. We just wanted to make the committee aware that there is a cost and an impact to the program. The reason we wanted to put a subcommittee together and discuss this is we can't quite get the calculations in our mind right about what the fairness of it is. The calculations that Adam had put together doesn't show us what the equality is. We just don't understand. We're looking at it from a different perspective. Mostly the lower income people, and if you give them half of what they would be entitled to, it might keep them on the public assistance rolls a little bit longer than they would want to be. So we just wanted to discuss it because we don't have the input that you have on your side to understand what the fairness of it was. It was bringing the NV Kids project to you guys was just an impact on timing, and it would be a cost. That was just an informational to you. It's not a deterrent on doing what's the right thing to do. So I wanted that on the record. That was not our intent. It was just, you guys need to be aware of the timing of where we're at.
Okay, thank you.
Okay, so we are building a state-of-the-art system, which can make changes a lot easier and quicker, but it's the timing of it.
Okay, great, thank you. I appreciate you addressing that.
You're welcome.
Additional comments?
And this is Adam Hughes for the record, and I can appreciate the pursuit of fairness and equity in this proposal, but there's also the presumption that the basic needs of a child are met by a child support obligation that's made under these current guidelines. And if we're dividing a joint custody order in half, I have to question whether those child's basic needs are still met under that calculation, especially when it, in some cases, will result in families being dependent upon welfare.
Any additional comment?
I guess this is Joe Sanford for the record. Obviously, we deal with these in the lower income bracket quite frequently, but I guess I would say prior to seeing these comments, I hadn't considered this issue very deeply from Senator Pickard's proposal. I think just on a gut level, I tend to agree with Senator Pickard, right? That before looking at it, you say, okay, well, it's just an offset. But when you see the idea of cutting in half, I can understand where it comes from on an equality standpoint. You can also see in cases of similar income levels, actually how it is even more effective in addressing, I think, a lot of issues that we see, or probably assume in the private bar, but also in our cases where there are strong motivations to play with what the custody is going to be and with what the incomes of each party are going to be, where, you know, if that child support was cut in half based off of the you know, the difference, you know, there's just less need to play those games. I do share some of the concerns in the instances of, you know, say a sole supported home, and then you get a situation where there's no income on one party and income on the other, and how that's going to end up working as far as meeting the basic needs. I know there are some ability to, already in our guidelines, to make deviations for the basic needs, and so I guess I understand and have the, you know, the thought that, you know, assuming we trust the judges to make sure that the basic needs are met through those deviations, I'm not as concerned, but I also understand that that is not always a great idea when, you know, to say, well, we're each case is going to have some independent judge level of deviation that could vary across the state. I guess my thoughts are, right now I'm generally in favor, but I would not be opposed to there is sure.
Mr. Sanford, I think we're losing you, or maybe it's just me. I can't hear you as well.
Oh, okay.
Oh, there, clear now. I don't know what happened.
Darn internet. But I'm not opposed to a subcommittee to, I think, ensure that if this does go through, we do ensure that the basic needs are met in these sorts of situations, because I hadn't really, you know, mostly it's just whether our original language that says it's assumed that this guideline calculation meets the needs, whether that could end up causing issues in the same vein.
Your comment reminds me, just also state on the record, we have to remember, and where I think we failed, is that the payor also needs to meet the basic needs of the child 50% of the time. And some of these payors are suffering in debt as a result of very large child support payments, yet they have their child 50% of the time. So that is the switching of the mentality on the joint custody cases, is that it's not the same as primary physical custody, where it does not have the child 50 to 60. Let's be careful with that language, that 50% of the time. But both parents need to meet the needs of the child, and yet one is gaining significant income from the other, and the other may be suffering. That's where we receive public comment from actual citizens, paying nearly every person that we had that gave us substantive public comment during our main committee meetings was in a joint physical custody scenario. We didn't have the primaries showing up and complaining, and we didn't even have the recipients showing up and complaining and saying they were having a hard time making ends meet. Additional comments? Judge Robb?
Bridget Robb for the record. It occurs to me, I've been listening, and I think there is something that people are forgetting when this particular part of the formula is being applied. The amount that is being split isn't the sole amount of child support. The court looks at the income of the receiving parent, the income of the parent who is paying, and it's that little bit in the middle where that portion in the middle where there's an offset. But there's already an assumption of child support by both parents that is being subsumed and that they have an obligation for. So it's not just, we aren't just talking about a $50 award taking care of the needs of the child. There is also the underlying amount that is there that is part of the formula. That's what is taking care of the needs of the child. And so I think we need to step back and remember exactly what that formula does, the entire formula, not just the offset, because the offset is not the entirety of child support, at least in my mind.
Senator Pickard?
Thank you, Madam Chair. Judge Robb just took half of my response. So the other part I wanted to respond to was that we're talking about two different things ultimately here, and that is the theory versus the practice. And we have to account for both. And I agree with that, and I appreciate what Ms. Kaplan and Mr. Hughes are saying on the practical side. I don't disagree with them. There will be instances where if we take $50 from $100 DVA or the difference, that might make somebody go into the red instead of the black, and now they need more public assistance. But I suspect that these are things that Judge Robb and Judge Hoskin and the hearing masters in the 4D program are likely to be able to resolve under one of the stay away from that word, the adjustments, and are worthy of findings, right? What I'm trying to do here is align the theory with the underlying policy of the state that both parents have an equivalent duty. And so by doing this, we're saying both parties are equally responsible for the difference, right? So the lower paying or lower earning obligor is going to pay a little more, and the higher paying is going to pay a little more. And here it's a numerical equality because we're dividing that difference in half. But at the end of the day, we're making the theory, the policy, the language of the guidelines match the underlying policy of the state. And then if the court or the hearing master wants to look at the details and say, look, in practice, this really would harm the recipient parent. And so under this other factor, because we've got the adjustment factors, we're going to ask dad or mom to pay that entirety of the difference to the recipient parent. And then we're also limiting the magnitude of the difference of that adjustment to the deviation, right? To the difference between the two incomes. So we're talking about a very narrow amount. And I think that the ability to keep somebody off the public rolls would be a legitimate reason to deviate or to adjust. But that's an adjustment, and that should be taken care of as an adjustment. We shouldn't be creating a disproportionate policy in the guideline inconsistent with the policy of the state. And so that's why I brought the proposal, was to make those two consistent and allow the courts to do adjustments as necessary to, among other things, keep somebody from having to continue on public assistance.
All right. Yes, Ms. Tollison, you just noted that Mr. Willick has his hand raised. He needs to wait for public comment before we open it up to him to make comments. We're still on committee. So there was a request from DWSS regarding a subcommittee, and that is something we can discuss. I'll tell you, my concern is in the past, when we have created subcommittees, it's because we didn't have language in front of us that we could consider. It wasn't for a subcommittee to go and debate policy, or this is good stuff that needs to be out there in front of the public to be discussed publicly, I think, on the record. If we were struggling with getting examples from other states and trying to figure out what words to use, that's when we've used subcommittees, because somebody needs to go roll up their sleeves and put some elbow grease into creating something for us to consider. And that it's my opinion that is not what we're doing here. We're actually debating the public policy behind this. And I personally prefer it be in front of the committee, but if the committee wants to entertain a subcommittee to consider this issue, I'm happy to hear everyone's comments on that and do as the committee wishes. Any comments? Any additional comments on the entire topic right now? Is this something that everybody needs to sit on? Do you want me to create a subcommittee? How do we want to do this?
Madam Chair, Keith Pickard for the record. I also, excuse me, hesitate to create a subcommittee, not only because it's inefficient, but it means there are conversations occurring outside the awareness of the committee. I generally tend to shy away from that. We have language. We have, if we need to do research, I have the LCB Research Division at my disposal. They can usually come back in a matter of a week or two with substantive responses. But in this case, it's not really about, in my mind, it's not really about comparing what we're doing with other states, because we already have made that analysis in the first go around. This is about tweaking the language that we have in ways that should be consistent with existing Nevada law. And that to me is more important. I don't believe we need a subcommittee, but you know, even though I'm prepared to make a motion to adopt this, if the group is in a position where they're not prepared to make that determination, I have no problem waiting for the next meeting.
Judge Rob, you have your hand raised technologically, but okay. But not physically, okay. You know, I want to add a little more comment, which is I think on joint physical custody, I don't feel this committee fully fleshed out joint physical custody. We really, it took so much for us to figure out the percentages and deal with low income and everything else that we really did lean towards just adopting what we already had in place versus making sure it worked within what all of our principles were within this committee. I can't say that we even have a system in place that compares to other states on joint physical custody, because I haven't really seen, even in the materials we relied on earlier in this committee, anything close to what we do on joint physical custody. A lot of states, which we shied away from in the early days, you know, do rely on percentage of time with the child and, you know, a whole different methodology of creating and calculating child support. I leave it to you, Senator Pickard, if you want to make the motion now, or if you want to let everybody sit on it right now. I have not heard, other than Ms. Kaplan and Mr. Hughes, are you still in the position you want a subcommittee, or versus allowing this to stay on the agenda a little longer for further discussion?
And this is Adam Hughes for the record. I would defer to Ms. Kaplan on the issue of whether a committee is necessary, but I would point out that Mr. Willig did provide some information for the committee regarding this topic. I believe it was 14 pages, and I don't know if the committee's had a chance to digest that. So I would request the committee to consider that before a motion is made.
Okay, that's fair.
Kathy Kaplan for the record, and I agree with Adam. I think I would like to have more time to look into it from the DWSS perspective, and I'm good with tabling it until the next meeting so that we have some time to do some more research.
Thank you. Echo. I would also appreciate if you could gather a little more information about the fiscal impact, the timing issues, the responsiveness to those issues. So with that, unless I have anybody wanting to do otherwise, I am going to move us on to public comment, allow this item to stay on the agenda, allow us all to digest it some more, perhaps do some individual research, and contemplate perhaps the AML materials and anything that may be there regarding this issue. We're moving on to public comment for agenda item number 10 now. And I do know that Mr. Willick had his hand raised. I don't know if he is still desires to give public comment or not.
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. Mr. Willick, you're unmuted, so please go ahead with your public comment.
And you have a 2-minute time limit, sir.
Very good. I'll be brief. I wanted to clarify that this is not a matter that the Academy chapter addressed as a group, but it is something that I looked at as some of the research into parenting time and the child support CLE already submitted. As a body, or if the commission's appointing a working group, the subject should be approached with some caution, I think. The mathematics of a cross-obligation offset like that set out in Wright is apparently currently used in 23 states, some of which I believe are Wisconsin guideline states. And before that approach is changed, the commission should probably examine the investigations and projections applied by those other states, all of which I think have apparently decided that a Wright type approach produces the fairest outcomes. The subject was touched on by the research of Jane Van Orr, who's the person tapped to do the review of the child support statutes leading to this commission. Citation to that research is in the submitted CLE. Thank you.
Thank you. And I would add to that, though, Jane Van Orr's analysis was done based on our old statutory makeup, 100% on the old statutes. She has not seen our new ones, and we have not had a current audit. Any additional public comment?
To give
Madam
public
Chair,
comment.
I'm sorry, Madam Chair, can I ask Mr. Wilk a question?
Yes, you may. He's still there.
Marshall, is he still, are you there, Marshall?
Yes.
Okay.
If I'm understanding what you're indicating, you're not espousing that this is the fairest approach. Is that a fair interpretation of your comment?
What I learned in the Academy mediation training is fair is a 4-letter word starting with F that we try not to use. But all I was trying to point out is that apparently there are 23 offset states, according to the research I reviewed. And I think it would be a wise precaution to either do the research or appoint somebody to do the research to find out what those other states have done and why they have done it, because I believe they've all come to the same conclusion. And if 23 other states have decided that crossed offsets under a Wright sort of approach is correct, I think that should bear on the deliberations of this commission.
Thank you. That makes it clear for me. Thanks.
And Madam Chair, if I may, this is Keith Pickard for the record. I have no problem reaching out, having LCB Research do that analysis for us. It is one of the perks of the job, I suppose, because I can always bring legislation on it if I need to. So I will reach out to them, have them do that research, and then we can table this until we get that research back. That should obviate the need for a subcommittee as well. Then we can debate the merits as we get the information.
Great, thank you. Appreciate it. All right. Any additional public comment from Ms. Tomlinson?
To give public comment, please raise your hand in the Teams meeting or press star 5 on your phone to take your place in the queue. I'm showing no other hands are raised at this time.
Okay, thank you very much. All right, we are going to move on to agenda item number 11, although I believe that may be one that we need to skip, but I know that Judge Hoskin and Senator Pickard, that was one that you were working on, but now with AML materials, I would assume you would like me to skip that agenda item.
Yeah, and we've gone back and forth with some language, and we didn't propose language because of the AML submissions. Certainly, their proposal is different than what we've talked about at this point in time with incorporating 130 into 140. But I think it would make more sense to resolve those issues before we propose new language as previously discussed. And certainly, Senator Pickard, I'll defer to you on that.
No, I agree totally. Keith Pickard for the record. I think that makes a lot of sense, so I agree.
Okay, thank you very much. We're gonna move on to agenda item number 12, discussion and recommendations on proposed language for NAC 425.150 and NAC 425.110 to define public assistance. I know a small issue came up last week, not issue, but a suggestion came up on that language. I don't know, Mr. Hughes, are you prepared on that for Ms. Cliff?
I am, yes. This is a continued agenda item from prior meetings, and as you mentioned, this is there was a discussion with Mr. Sanford at the last committee meeting to eliminate or modify some of the proposed language. I believe the section he had a concern with was whether someone had applied for temporary assistance in the past, and I'm not sure if he had come up with some language, but if he hasn't, I have a proposal for the committee.
I do believe Ms. Baker also had some input on that, but please go ahead, Mr. Hughes.
Thank you. So my proposal for the committee would just be to delete the last half of that sentence. The part specifically was and has not applied for temporary assistance for needy families cash assistance. That would just leave the first part of the sentence. So subsection D would read, contain a certification by the obligee that he or she is not currently receiving temporary assistance for needy families cash assistance.
Okay.
And I have further comment for section 425150 if you want me to address that.
Yes, please. That's also included in the agenda items, so you're covered.
So at the prior committee meeting, we addressed this topic, and I don't know if there was any concern related to this, but this is another attempt to define public assistance in the NAC 425. We've added a reference to NRS 422A065, and that's in subsection 425150D, and that's just to further define public assistance in that section.
Okay. Does the committee have any questions for Mr. Hughes on that?
Yeah, since I don't have this is Keith Picker to the record, since I don't have the proposed language, Mr. Hughes, will you please go over the 110 language again for me?
Sure. So 110 is a section of the code that allows the parties to stipulate to an amount of the child support that when that amount doesn't comply with the guidelines. To be binding, it currently requires a certification by the obligee that he or she is not currently receiving public assistance and has not applied for public assistance. The proposed change to the section is designed to narrow that type of public assistance considered under this section to only the temporary assistance for needy families, cash assistance only. So the proposal is to change the language to contain only
Oh, we lost you.
Oh, sorry, I was just catching my place there.
Oh, okay. Sorry, I thought it was. I thought it went blank.
So subsection D, instead of referencing public assistance, will only state contain a certification by the obligee that he or she is not currently receiving temporary assistance for needy families, cash assistance.
All right. So there were two components to subsection D that we were trying to capture. And that was, first, are they currently receiving the public assistance of any kind? And the second piece was they've not applied to but not yet receive that assistance, because what we often will see in practice on our side, and I assume it must occur more frequently on your side, that someone may have applied but not yet received, so they say, hey, I'm not getting it, when in fact they're about to get it because they just haven't finished the process. So is there a way for us to capture that second piece so that we're not going beyond the intent here, that they're certifying that this is going to meet the needs above, but then down below that we're trying to make sure that we're not getting somebody that's or we're not including in this agreement between the parties that they're not on public assistance, because of course one of the objects is to make sure that we're not creating child support orders that force parents to be on public assistance. So how do we capture those that have applied but are not yet receiving? Or is that not a concern?
And this is Adam Hughes for the record. So the initial proposal was that we would capture those that are currently receiving TANF, and then the second part of it was, and has not applied for temporary assistance for needy families cash assistance. And Mr. Sanford had some issue with the second half of that, the people who had applied for temporary assistance for needy families. I believe his concern was that someone may have applied in the past and that obligation may have already been paid for and resolved. I believe it's the state's position that if someone is applying for TANF, we can always go and modify that order subsequently to capture that. So we could catch that amount.
Apologize. This is Joe Sanford for the record. I had prepared some language that was to address that, which was to change it to a pending application. I received Mr. Hughes' adjustment, which was to delete it. And actually, I determined that that was my preference as well, which was to just delete it and accept that if they had applied and had not yet received it now, which was the pending application, even if they'd entered into a stipulation, that we would proceed with that, with a modification at that time. When it, those types of cases, they assign their rights over to the state, then the state has an affirmative duty at that time. This is a fairly infrequent case, I think, at least as far as the 4D program is concerned, where they have an application, are not receiving, but are also proceeding with a stipulation. Very, very frequently in our cases, no one will, prior to the involvement of the state of the 4D program, there's almost never any action towards either stipulation or court action at all. And so I think that the number of cases this catches was fairly limited. My concern before was the ones where it was they had applied and received, or applied many, many years ago, and that would be a barrier to their stipulation.
Okay, so for clarification, the language will just end at not currently receiving TANF. Or spelled out, temporary assistance for needy families.
Yes, temporary assistance for needy families, cash assistance.
Yep. Okay. And that's for 110, and then on.
Madam Chair, before you go on to the other section, can I ask a question?
Yes.
I'm maybe I'm a little confused as to why this is a focus. This is simply informational. This is not we're not modifying as a result of this information, simply the certification they provide to the court before we accept a stipulation that's contrary. So I think, in my mind, and maybe I'm missing something, I would want to know if they've applied as part of that representation to the court for me to certify that it's acceptable and meets the standards. So I guess I would like to understand why it is that we wouldn't have them provide that information. Is it a 4D issue that I'm just not aware of?
And this is Adam Hughes for the record. I don't believe it's a 4D issue. The object of this proposal was simply to clarify public assistance is only limited to TANF. We're not asking for the court to stop a stipulation if a party's applied for or received Medicaid or housing assistance. It's just for TANF.
Right, and Judge Hoskin again, and I understand that, and certainly I don't have a problem with you putting TANF in there instead of public assistance, but I was a little confused as to why we would take away or have applied for TANF as part of the certification, and I don't recall specifically why we as a committee put that in to begin with, but I want to say it was a 4D request, but I don't have a memory back that many years.
And this is Joe Sanford for the record, and I believe the request is based off of the 4D program, with the idea that once someone applies for TANF, they assign their rights over, and then the 4D program will start to try and enforce a case, establish an order, and things like that. And I think at the time we didn't want to have stipulations where we're going to be having a concurrent, attempt by the 4D program to create an established order, and then we get the stipulation. And so I think that was why it was in there originally. Unless it came from somewhere else, but that's my belief on why it was in there.
And I think, and I could be wrong, Judge Hoskin again, but I think this would only affect the 4D programs given the way that we're looking at it. So if, in my mind, if the DAs are willing to take that out, I don't know that I want to step in the way, but I just wanted to understand why we would do that.
Okay. Any additional comments or questions on section 110? Okay, so that language, just for clarification before we have a motion, is that 425.110 will now, subsection D, 1D, will now read, contain a certification by the obligee that he or she is not currently receiving temporary assistance for needy families, cash assistance, semicolon. Okay. And then for 150, nothing's changed from the prior meetings, correct?
This is Adam Hughes. That's correct.
Okay, so that still reads 425.150, 1 subsection D now reads any public assistance as defined in NRS 422A.065 paid to support the child, semicolon. Okay. Would someone like to make a motion to approve those two changes?
This is Adam Hughes. I'd motion for the committee to adopt that.
All right, thank you, Mr. Hughes. Do I have a second?
This is Joe Sanford. I'll second it.
All right, thank you, Mr. Sanford. Any further discussion? All in favor, state aye.
Aye.
Opposed, state nay. Any abstentions? All right, motion passes unanimously. All right. Now, we already completed agenda item number 13. So our next agenda item is 14, discuss and approve ideas for future agenda items. I will state, depending on what I receive from the public comment at the beginning of the meeting, I may be adding those items to the agenda. And do we have any further discussion from the committee on additional items you want to see added? I will restructure this some based on the AAML materials and try to break it into pieces so that it's a little more palatable about what we're talking about in each agenda item based on the new materials.
Kathleen Baker for the record. This may be covered by the AAML information, but I'd like to go back and talk a little bit more about our basic child support formula. We are in the process of adjusting it to include the child care costs. There was some discussion about what we were going to do with the medical costs, and I would just point out that in the previous statute, both child care and medical costs were deviation factors. And so it seems to me that if we do not have an adjustment factor for the medical costs, we may want to consider making that part of the, not medical cost, medical insurance cost, make that part of the formula itself. I thought that's what we talked about, to have sort of mirrored language that we have for the child care costs in terms of the cost of the sharing the medical insurance premium. So I'd just like to revisit that.
Okay, thank you. Additional items for agenda consideration?
This is Joe Sanford for the record. I don't know if it's necessarily an additional item. I guess I would like perhaps either a naming convention or something that is coming from how the materials are presented that makes it clear when it's documents that are being provided by a committee member, or specifically Ms. Surratt and her master document, and whether it's something that's being provided as a public comment material or something like that, because there's quite a few different people providing different statutory changes and suggestions. And I guess I would just like to know and ensure that I'm clear on which ones are from the committee and have been adopted or are pending adoption, and then which ones are being provided as public comment as potentially to be adopted. I think it was okay clear this time, but it was a little bit more difficult for me to follow. And so hopefully we can just have maybe either in separate emails or just something that makes that a little bit easier.
Absolutely, I agree with that. You will receive the master document this next time. The 3 things that will be in it are just the things that we have made motions on and approved. And that would be the definition of self-employed income and the public assistance items that we just voted on. I don't have complete approval on anything else for changes, but I will get that out. I am titling it master document, but I will figure out a way to change the name of anything that comes in, and we'll make sure it's clear who it's coming from. I agree. Additional comments on agenda items or administrative type items? All right. I have noticed, I don't know, Ms. Kaplan, if you know this, because Ms. Chappell may be the one to have the answer. I did notice that only a couple of the hearings have gotten up on the website. Do you know what the status is on that?
Kathy Kaplan for the record. I do not know the status, but I will look into it and find out where we're at with that, and I'll send you an email.
Thank you. I know the public reached out. For the public that's listening, please know that we have a duty to conduct our business through these meetings publicly. We're not here as, we can't do your research for you, but we're trying to get the materials up on the internet for you and allow you to do those interpretations. As a committee, we have to conduct business as a committee. All right. Anything else for agenda item number 14 before I move on? Okay, hearing none, we will now move on to public comment. Those who give public comment during this section of the meeting are limited to 2 minutes.
To give public comment, please raise your hand in the Teams meeting or press *5 on your phone to take your place in the queue. I'm showing no hands are raised at this time.
Okay, thank you. Again, I appeal to the public to please provide ideas and suggestions and reach out for agenda items. Our purpose is to be here for you, for the public, and to make changes that are for the greater good of the state of Nevada and its citizens and its children. So without input from the public, that is difficult to do. So spread the word when we have meetings. We'd love for you to attend with us. With that, I'll take a motion to adjourn.
Move to adjourn.
All right, thank you, Judge Rob. All right, all approve?
Aye.
Aye.
Opposed? No. All right, thank you, everybody. We did not talk about the next date. With Christmas holiday, I believe we will be right after the 1st of January, so I will get dates out to everybody.
Thank you,
All right,
Madam Chair.
thank you, everyone.
Thank you.
Thank you.
Thank you.
Happy holidays to everybody.